Section 4. Resolution of investigating prosecutor and its review. Of the investigating prosecutor finds cause to hold the respondent for trial, he shall prepare the resolution and information. He shall certify under oath in the information that he or as shown by the record and authorized officer has personally examined the complainant and his witnesses, that there is reasonable ground to believe that a crime has been committed and that the accused is probably guilty thereof, that the accused was informed by the complainant and the evidence submitted against him, and that he was given an opportunity to submit a controverting evidence, otherwise he shall recommend the dismissal of the complaint. Within 5 days from the resolution, he shall forward the record of the case to the provincial or city prosecutor or chief state prosecutor, or to the ombudsman or his deputy in cases of offenses cognizable by the Sandigan Bayan and the exercise of its original jurisdiction. They shall act on the resolution within 10 days from the receipt thereof, and shall immediately inform the party of such action. No complaint or information may be filed or dismissed by an investigating prosecutor without the prior written authority or approval of the provincial or city prosecutor or chief state prosecutor or the ombudsman or his deputy. Where the investigating prosecutor recommends the dismissal of the complaint, that his recommendation is disapproved by the provincial or city prosecutor or chief state prosecutor or ombudsman or his deputy on the ground that the probable cause exists, the latter may be himself file the information against the respondent or direct another assistant prosecutor or state prosecutor to do so without conducting another preliminary investigation. If upon petition by a proper party under such rules as the Department of Justice may prescribe or motopue, the Secretary of Justice reserves, reverses the city prosecutor or chief state prosecutor shall direct the prosecutor concerned either to file the corresponding information without conducting another preliminary investigation, or to dismiss or move to dismissal of the complaint or information with notice to the parties. These same rules shall apply in preliminary investigations conducted by the officers of the Office of the Ombudsman. Section 5. Resolution of investigating judge in its review. Within 10 days after the preliminary investigation, the investigating judge shall transmit the resolution of the case to the provincial or city prosecutor or to ombudsman or his deputy in case of offenses cognizable by the Sandigan Bayan in the exercise of its original jurisdiction. For appropriate action, the resolution shall state the findings of facts and the law supporting his action, together with a record of the case, which shall include the warrant if the arrest is by virtue of warrant, the affidavit, counter affidavits, and other supporting evidence of the parties. The undertaking of the bail of the accused and the order for his release. The transcript of proceeding during the preliminary investigation and the order of cancellation of his bail bond if the resolution is for the dismissal of the complaint. Within 30 days from receipt of the records, the provincial or city prosecutor or the ombudsman or his deputy, as the case may be, shall review the resolution of the investigating judge on the existing probable cause. Their ruling shall expressly and clearly state the facts that the law on which it is based on the party shall be furnished with copies thereof. They shall order release of an accused who is detained if no probable cause is found against him. Section 6. When warrant of arrest may issue by the regional trial court within 10 days from the filing of the complaint or information, the judge shall personally evaluate the resolution of the prosecutor and its supporting evidence. He may immediately dismiss the case if the evidence on record clearly fails to establish probable cause. If he finds probable cause, he shall issue a warrant of arrest or a commitment order if the accused has already been arrested pursuant to a warrant issued by the judge who conduct the preliminary investigation, or when the complaint or information was filed pursuant to Section 7 of this rule. In case of doubt on the existing of probable cause, the judge may order the prosecutor to present additional evidence within 5 days from notice, and issue must be resolved by the court within 30 days from the filing of the complaint or information. B. By the municipal trial court when required pursuant the second paragraph of section of this rule, the preliminary investigation of cases falling under the original jurisdiction of the Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, and Municipal Circuit Trial Court may be conducted by either the judge or the prosecutor. When conducted by the prosecutor in the procedure for the issuance of a warrant of arrest by judge shall be governed by paragraph of this section. When the investigation is conducted by the judge himself, he shall follow the procedure provided in Section 3 of this rule. If his findings and recommendations or a form of provincial or city prosecutors or by or by the ombudsman or his deputy, and the corresponding information is filed, he shall issue a warrant of arrest. However, without waiting the conclusion of the investigation, the judge may issue a warrant of arrest if he finds, after an examination in writing and under oath of complainant and his witnesses in the form of searching question and answers, the probable cause exists and there is necessary of placing the respondent under immediately custody in order not to frustrate the ends of justice. C. When warrant of arrest not necessary. A warrant of arrest shall not issue if the accused is already under detention pursuant to a warrant issued by the municipal trial court in accordance with the paragraph B of this section, or if the complainant or information was found pursuant to section 7 of this rule, or for offense penalized by only by, by, by fine only, the court shall proceed then proceed to exercise of its original jurisdiction.